Hi, my name's Olivia and I'm a legal director in the employment team at Birketts, specialising in acting for clients in the financial services sector. Thank you for joining me today. This is the third in a series of short videos aimed at individuals working in HR, compliance, or with people responsibilities in businesses regulated by the FCA. In our first video, we looked at what non-financial misconduct is and what changes are being proposed by the regulator. And in our second, we looked at what you need to do to investigate conduct rule breaches and when to get the regulator involved. Today, we're going to be looking at regulatory references, what they are and what you need to put in them. Regulatory references were first introduced for banks and insurers regulated by the FCA and the PRA back in around 2017 under the Senior Managers and Certification regime. Regulated employers must seek to provide regulatory references for those that they intend to appoint into certain roles, including employees, contractors, and even non-executive directors. They were introduced to stop individuals with poor conduct records moving from job to job without many consequences. In other words, what became known in the industry as rolling bad apples. A special template was created for the requests and responses, which set out specific questions seeking to elicit information about any past misconduct or fitness and propriety issues. Firms must take reasonable steps to obtain a regulatory reference from an individual's current employer and anyone who's been at their employer in the past 6 years. Firms must make reasonable efforts to obtain the reference, and there's no territorial limitation. So even if you're appointing an overseas candidate who has never been subject to the FCA's jurisdiction, you'll still need to try to obtain a reference from them, albeit that overseas employer isn't necessarily obliged to provide one. It's important to note that firms and individuals cannot contract out of this obligation. For example, you can't agree as part of a settlement agreement to say something different in the reference or not mention any misconduct that you're aware of. Firms are also under an obligation to update a regulatory reference if there is a significant change to the information provided, whether new facts have come to light or the firm reaches a new conclusion regarding fitness and propriety. In terms of what to put in the reference, question E, F and G of the template are the most important. Question E asks if a firm has concluded that the individual is not fit and proper to perform a function. Question F is a yes or no question format concerning disciplinary action that is relevant to a breach of a conduct rules or to whether a person is fit and proper. And question G is whether you're aware of any other information that you reasonably considered to be relevant to your assessment of whether the individual is fit and proper. So G is the catch-all question that causes the most head scratching across the industry. What a firm reasonably considers relevant to disclose can vary considerably, especially in respect of matters where someone has resigned partway through an investigation. Some firms will say nothing here, others will explain the resignation partway through, and others will complete the investigation and make a finding as to whether they would have dismissed had it not been for the resignation. Firms completing references must disclose any potential misconduct in the previous 6 years, or if there's been serious misconduct, there's no time restriction. Individuals don't have a right to input into the contents of a reference. Those who do wish to dispute the contents could claim for negligent misstatement where a firm has not exercised proper skill or care, or bring a defamation claim if an individual considers that untrue statements are contained in it that might damage the reputation. It's important to recognise that a negative reference can significantly undermine a person's ability to find new employment in the industry. So in other words, they have the potential to be career-ending. Where claims have ended up in an employment tribunal and a claimant has won, the tribunal will often make an award of compensation that reflects substantial or even career-long losses where there's a negative reference. There have also been examples where, having seen the wording of a regulatory reference, a tribunal has ordered employers to rewrite it, reconsider its contents, or even in one case proactively write to the FCA to tell them that the individual was unfairly dismissed and append a copy of the judgment to the letter. Failing to follow these orders can have further ramifications and compensatory repercussions for the company. Thank you very much for joining me today.